Thank you, Madam Chairperson. The bill is regarding the Admiralty Jurisdiction and Settlement of Maritime Claims Bill 2016. Already other two speakers have spoken. I will not take much time. But firstly, I point out that I respectfully disagree with the statements made by the Honorable Minister. The Minister, while making this statement, said, bill is also covering the environmental issue. I am sorry, sir. Under clause 4, this is not the scope. You have also referred to that in case of leakage of oil and etc., this will come within the purview of this. This is also not there. Therefore, I respectfully disagree with the statements made by him in respect of two issues. That is the reason I was trying to tell him, kindly restrict yourself without giving the long lecture, restrict yourself with the object and reasons of the Act itself, not beyond that. This Act was necessary for long, rather I say decades after decades. There is no quarrel with that words. It is unfortunate that although Supreme Court in 1992 directed the central government to come up with a law which will fulfill the need of the days when 151 reports of the Law Commission was existing. But unfortunately from 1992 to 2016, whatever the governments were there, whether UPA government, NDA government and other coalition governments, no one did not pay any heed to that circumstances. Today it is needed, and therefore I am not opposing in substance of the bill is concerned. Madam, I will take two or three things. The claim of which is required to be decided by the High Court by reason of this enactment of the Act itself has been codified under clause 4. I will not read because it will take much time to read. The jurisdictions have been said here. Now, territorial water. Madam, in practicality and in reality, and just my predecessor friend, just earlier, he has hinted how, I agree with him, that really the trouble starts. The clause 2, subclause K, territorial water shall have the same meaning as assigned to it in the territorial water, continental self-exclusive economic zone and other maritime zones, 1976. Simply it is said in law, incorporation of a statute. You have incorporated a provisions, and that is a vague provisions. That is a vague provisions. Very correctly he has said that decades after decades, it takes away the point, it takes away the question, jurisdiction, which High Court is having the jurisdiction in the sea itself. I have an experience, being a lawyer, that we had a dispute with the Odisha government in respect of territorial water. However, both the Honorable Chief Minister, they have discussed and resolved the problem. And it is working now very good. Therefore, here is the extremely vague thing is there. Now, Madam, I come to, and I will point out to the Honorable Minister, kindly clarify this. This is bringing in another area where more interpretation is required to be done by the court. You have to clarify and you have to clear it. Clause 17, subclause 2. Start. Notwithstanding the repeal, all admiralty proceedings pending in any High Court, immediately before the commencement of the Act, shall continue to be adjudicated by such court in accordance with the provisions of this Act. What does it mean? What does it mean? Firstly, before the case shall continue to be adjudicated by such High Court. If you have said, it's all right. The moment you are saying in accordance with the provisions of this Act, then whether Calcutta will go to Odisha will, or any other places will go to other, clarity is not there in this section. You have to clarify that situation. This is I think, I do not know what is in your mind. If a proceeding is pending before a High Court, it will continue in the High Court, then language of that statute would have been made clear. If the proceeding will be transferred as on today, then you have to write it down, it has to be transferred. You are creating a confusion by saying before the Commencement Act shall continue to be adjudicated by such court in accordance with the provisions of this court. The moment you are saying in accordance with the provisions of this court, then the transfer of this Act, therefore the entire, all the High Court jurisdictions comes in. Therefore this is a contradiction there. It has to be clarified. Not for argument's sake I am making this argument. I am trying to help you. That's the reason I am telling you, clarify it, you clear it, and if clarity must be there in this statute. No, unfortunately we are seriously criticized in the judicial sector because of the bad drafting or wrong drafting of a statute. I think this clarity needs to be required in the provision itself. Now, so many things have been said regarding the old acts and etc. Yes, old acts which are not required, that have to be repealed, that is also necessary. Old act also did not made applicable to us. Now I am coming a very important point. I know that it is not concerned about you, but through you today in this house, I am making this point to the nation itself. It's a national problem has come. Now, you are giving the jurisdiction to the High Courts to decide. There is no difficulties. But the Honorable Minister, do you know how many vacancies are there in the High Courts? How the High Courts can take load of all these things? Vacancies are not being fulfilled. Earlier, some days, 2 or 3 sessions back, few acts have come, jurisdictions haven't been given to the High Court. No problem. But with the load which are there, jurisdiction which is there, not a single High Court is in a position to function. If I correctly say, so far the Allahabad High Court is concerned, almost 50% posts are vacant. Calcutta is concerned, nearly 50% is vacant. In all High Courts, this is not in a single High Court. Now why you are not fulfilling the vacancies? You see, National Judicial Appointment Bills were passed here, constitutional amendment was made, ultimately Supreme Court has declared ultra vires, we have to accept this proposition. If we have to accept the proposition, we can't have any ego on that. Neither in legislature nor parliamentarian, nor a central government or any government cannot have any ego with the judiciary. This has to be sorted out. I know it's not your problem, but today, since the High Court part has come, through you I am trying to tell, please remove the ego. If there is any ego with the judiciary regarding the filling up of the vacancies, kindly fill up the vacancies first. Unless you fill up the vacancies, not only this one, nothing will be done. Whenever a matter is taken up regarding Admiralty jurisdiction is concerned, Maritime, I don't know whether you are having the experience or not, for a small point, it takes whole day to decide. Other business is closed normally, because big claimants are there, big lawyers are there, big fees are there, big things are there, naturally much times are there. who will take care of the poor people of the country? Everyone is taking care of the rich people of this country. That is the whole problem. I am not blaming you. It's not your fault at all. But through you, I am trying to tell you that see to this vacancies have to be filled up. Now, in respect of appellate forum, you have made it very clearly, very nicely it has been done. Single bench, then the division bench, appeal, including interlocutory, everything has been done. And against that, Mr. Chaudhary is not there. You are saying what would be happened thereafter. Against that, Article 136 of the Constitution of India is available. It is known to that. You are not required to mention that. That is all right. There is no difficulties on that. And the Supreme Court will decide if any cases of a transfer, whether it's needed, whether it's a Calcutta jurisdiction or the Odisha jurisdiction. Naturally, Supreme Court will decide. There is also no difficulties at all. Now, another one point, just I say to you. Yes, I must. I have covered my points. Otherwise, everything is very clear. In future, my suggestion to you. It's very difficult job. Of course, I am suggesting. I know I am suggesting, but it's a very difficult job for you also. This territorial water jurisdiction has to be identified. Now it is not much difficult because of the new mechanism has come, satellite, etc. Other things have come through this. If jurisdiction is there, just like taking my friend Mehtab Sahib is there, Calcutta, West Bengal and Odisha, water, that you have to identify that part. If you identify that part, you will find the question regarding the jurisdiction by the court, that would be lesser and that would be easier job. In future, if you try to do it, it will be great helpful. That suggestion I am giving. With this, I give you thanks. From 1992, it doesn't give a good smell in our mouth. That from 1992 it is pending. Now it has been brought. Let it be passed. There is no difficulty. With this, I conclude. Thank you.
Thank you, Mr. Banerjee.